Good afternoon, folks. My name is Ken Gorenberg. I'm a partner in the Chicago office of Barnes & Thornburg. Welcome to our webinar today entitled You're Covered But. We have three scheduled speakers who will engage us from several different Barnes & Thornburg offices in a couple of minutes. But first, there are a couple of housekeeping matters and then some special items of interest today as well. First, as a matter of housekeeping for the many of you who are logged on here seeking CLE credit, that will be available. There will be a couple of times during the course of the webinar where you will have to click something to indicate that you are still paying attention to the webinar, and that's in compliance with the rules in certain states. Also, we are recording this webinar today, and we are also going to be making both the recording and the slides available to those who would like them after the program. And that also means that if, for example, you want to share this material with others in your office, just let us know and we'll be happy to arrange that for you. So I think we are ready to get into the meat of today's session. And before we get into the scheduled speakers, as I mentioned, we have a couple of interesting things to report by way of updates today. There you see, my name is Ken Gorenberg. I'm your moderator today. We're pleased to be joined today also by the two co-chairs of our Insurance Recovery and Counseling Practice Group, Andy Deathridge and Charlie Edwards, who have a very exciting development to tell us about right now. Andy and Charlie?
All right. This is Andy, and I'm going to start, and then Charlie and I are going to go back and forth very quickly. Charlie and I just finished a 6-week trial in Nashville against 17 insurers, and we want to report a little bit about that today. Charlie and I were the lead counsel trying the case. This case arose out of a May 2010 flood in Nashville that flooded a 1.5 million square foot mall down in Nashville called the Opry Mills Mall. As a result of the flood, there was extensive contamination and damage in this very, very large mall. Unfortunately for our client, the insurers late that summer denied coverage and began to complain about the remediation and planned reconstruction work. We initiated litigation in September of 2010 based on the denial. The mall was able to get financing and get reopened in March of 2012, but we didn't have a trial until this summer, so the trial started on July 13. So before we get to that, Charlie's going to tell you a little bit that the case involves some very unique and significant legal issues that Charlie's going to walk you through, and then we'll tell you briefly about the trial outcome.
Yeah, well, I'll leave the trial outcome for Andy, but we did have a lot of, this is Charlie Edwards, and we did have a lot of legal issues that we'll probably be rolling out some thoughts about to all of you, over the next several months. But the first battle we had to win was that the insurers claimed we only had $50 million in coverage. We claimed we had $200 million in coverage. So we had a lot of discovery and summary judgment motions and other motion practice around that. And in March, some of you may recall, we ended up getting summary judgment where the court said we had $200 million in coverage available. So the July trial was about what damages there were and what damages were covered. And I won't step on Andy's punchline on that, but we did very well. This is some policy language we've dealt with, and some of you may have in your policies, so we don't have time today to go through it, but it related to high hazard flood zones and FEMA designations and those types of things, although we had kind of unique coverage here. And then we had something like 26 motions in limine that related to legal issues under property coverage, everything from what, if any, improvements and betterments are covered to quote-unquote delays in the period of recovery and what the period of recovery encompassed. And as Andy said, we had to get financing of $120 million to put them all back together. And the question of whether we received the interest payments on that loan, which the jury ultimately awarded to us, among other things, and the question of whether our business interruption loss would include the period of time that it took to negotiate and close that loan. And the jury ultimately gave us 100% of our business interruption loss. So I think they answered that question for us as well. So a lot of legal issues can't talk about today, but look forward to in the future. We'll kind of bring everybody up to speed on those issues, and then, like I said, I'll let Andy finish up with the actual outcome of the trial.
All right, thanks, Charlie. So last Thursday, the jury gave us a verdict for $204 million. They essentially agreed with us on the remediation and reconstruction costs. The business interruption, which as Charlie described, was a significant issue that Charlie briefed and argued and really set the stage for the trial. And they gave us, importantly, consequential damages on top of the policy limits, which is rarely done, and we thought was a significant outcome. So we were very pleased. It was a 5-year litigation, culminating with a very long and difficult trial against a bevy of lawyers representing the 17 insurers, but very pleased to get the outcome. Essentially got everything we wanted and that we asked the jury for, and then some, after only about 4.5 hours of deliberations after a 6-week trial. So very excited about that outcome, and as Charlie says, we look forward to bringing you some additional issues and things of interest from that trial and from the case that may be applicable to lots of folks.
Yeah, and on the consequentials, I guess I should mention that although the case was tried in Nashville, we argued for and were successful in getting Indiana law to apply because the policies were issued to our client in Indiana. And under Indiana law, a policyholder can get, as you may have noticed, consequential damages even if they exceed your policy limit. So that was a fortunate ruling for us and allowed us to exceed the policy limits on our consequential damages.
That's great, Andy and Charlie. Thank you very much, and thank you also for being great symbols and leaders for our practice group and for our audience. You know, we really couldn't be more proud to have leaders of our practice group who are not simply management figureheads, but are out there actually litigating and trying these cases for us and for our clients every day. So it's a tremendous development. We're very proud of it. The next development that I wanted to report on very briefly is, to borrow an unfortunate pun from hearing about a flood, this is a sea change in the law on a very important issue. There are a number of cases throughout the country that have addressed the interesting question of what happens after a number of corporate transactions, what happens to the insurance policies. And especially this is important when you have long-tail claims such as environmental and asbestos liability claims that we all deal with every day, where the incidents, the events that actually lead to the underlying litigation happened decades ago, and there are often multiple corporate transactions that happen subsequently. Now, insurance companies, almost every insurance policy has a provision in it that bars assignment of the policy without the insurer's consent. And many insurance companies have taken the position that that means that a second or third level down transaction means that there is no coverage, even if this alleged successor company is now defending the same cases that otherwise would have been brought against the original named insured. Now, the majority rule in most jurisdictions is that the insurance policies basically follow the liability, so that if a current entity is holding the liability for the activities of a past entity, it still has the same rights to those insurance policies as well. Back in 2003, California unfortunately joined the minority and started what looked like a potentially dangerous trend of agreeing with the insurance companies that those assignments were invalid because they were made without the insurance company's consent. Well, we are very happy to see that just last week the California Supreme Court reversed itself. We don't need to get into the details under specific provisions of California law as to why it did that, but this is a tremendous change in the law in California that prevents the potentially devastating tide going the wrong way. And just to make sure that everyone understands that while we obviously are advocates for policyholders, this is a result that simply makes sense. We are talking about matters where the underlying events that give rise to the coverage issues happened when the original named insured was still the one doing the business, incurring the risk. And there is no change in the risk that the insurance company underwrote that results in a claim many, many years later. So there is no reason why, from a policy and underwriting standpoint, an insurance company should have a problem with this. They are really just taking advantage of misapplication of a provision in their insurance policies. So we're very pleased to see that the tide is going the right way on this issue. So without further ado, we will now move into the originally scheduled parts of our program today. And I want to let our audience know that you will have an opportunity to ask questions really at any time. You should see on the right side of your screen a Q&A box. You can type your questions in at any time. Our speakers may take some of those questions while they are presenting, but in addition, we'll have some time after each presentation and at the end of our entire session to deal with some of your questions. And of course, you also will have the contact information for all of the speakers, and we would be happy to hear your questions and field them after today's presentations as well. So our first scheduled speaker today is Bob Davetsky, and he's presenting on the subject of full coverage and insurance agents' duty to advise. Anyone can see Bob's bio on our website, but I wanted to just give one brief highlight that Bob's undergraduate degree was in biology. However, that does not mean that he uses a microscope to read the fine print in contracts. Bob, take it away.
All right, Ken, thank you very much. I'm talking today about insurance agency or an insurance agent's duty to advise, and this topic comes to light as a result of a blog article I wrote a couple of months ago for the BT Policyholder Protection blog. That's Barnes & Thornburg's policyholder insurance blog, and if you haven't had the opportunity to take a look at that blog, I would strongly suggest that you do so. It's an excellent source for insurance information. It keeps up to date on new issues that come about in the insurance industry that are really important, and again, I encourage you to take a look at it. But the blog post that I wrote dealt with a recent Indiana Supreme Court decision in the case of Indiana Restorative Dentistry versus the Laven Insurance Agency. And I haven't seen too many cases come down where the Indiana Supreme Court has taken an interest in this idea of the agent's duty to advise. So I felt it was worth the blog post, and it's been fairly well received. My talk deals with the question of when does an insurance agent have a duty to advise a customer purchasing an insurance policy about the types of coverage that the new policyholder should be looking for. And of course, that question about the duty to advise is only asked when an insurance claim has been denied. Of course, if the insurance company is honoring claims, then the policyholder is never going to be looking to the agent for any duty to advise. And likewise, if the policyholder is fortunate enough not to experience any claims, then again, he's never going to be looking to the insurance agent as if there's some sort of duty to advise that hasn't been met. So what do we mean by the duty to advise, or what do we mean by advising the policyholder? And really what we're referring to is providing the policyholder with the right policy, or policies plural, the right limits of coverage, the right deductible, or really anything that causes there to be less than full coverage from the standpoint of the policyholder when the policyholder experiences a claim. And that could be a loss or a liability event. And in my cartoon here, I'm just pointing out the differences of opinion that you get when you don't communicate clearly between agent and the agent's customer as far as what full coverage means. And as I said, the duty to advise only matters when the claim gets denied. So let's talk about a typical situation. Typically, the customer of the agency comes in to purchase an insurance policy and does so. Somewhere down the road, the policyholder experiences a loss or a liability event which gives rise to a claim. That claim is then reported to either the agent or directly to the insurance company. The insurance company investigates the claim and denies the claim. And under those circumstances, sometimes you get a policyholder who then asks the agent, why don't I have coverage? I came to you looking for coverage. I paid my policy premiums. I had an event that I felt should have been covered, and my question for you, Mr. or Mrs. Agent, is why don't I have coverage? And the general rule is that the insurance agent has no duty to advise. Like all general rules, the no duty to advise rule has its exceptions. And that's really what we're going to talk about here today, are situations where we have exceptions to this general rule that there is no duty on the part of the insurance agent to advise the customer about coverage questions. I've put this case up, Third Eye Blind versus Near North Entertainment Insurance Services, because I loved the idea that you could look at the title of this case and pretty much figure out what it was all about. Third Eye Blind, this for those of you who aren't aware, the Third Eye Blind case is a California case, and for anyone who's interested in citations, it's at 26 California Reporter 3D 452. It's a 2005 case, but for those of you who don't know, Third Eye Blind is a rock band who experienced quite a bit of success in the late 90s. And as the 2000s rolled around, they experienced a problem that a lot of rock bands have experienced, and that is discord among the members of the band. So they wind up kicking out one of the original members of the band, and what does the fired band member do in a situation where there's a lot of success going on with the band? He sues the other members of the band. So you've got the fired member of Third Eye Blind suing the other members of Third Eye Blind. What's he suing them for? Well, he's suing them for things like trademark infringement, claiming that he has the right to the name Third Eye Blind. He's suing them for misappropriation of the right of publicity, something that was in the news just last week with Michael Jordan getting a $9 million verdict against a grocery store chain for using his likeness without paying him for it. And Lanham Act violations, federal Lanham Act violations, claiming that the fired member of the Third Eye Blind band was entitled to royalties he wasn't receiving from the other members, the remaining members of Third Eye Blind. Well, Third Eye Blind did what anybody else does when they get sued. They tendered the defense to their insurance agent, who then turned it over to the insurance company. When they did so, the insurance company investigated Third Eye Blind's claim. Third Eye Blind was just asking for the insurance company to come in and defend them against this lawsuit filed by the fired member of the band and provide any coverage that may result from any verdict obtained or settlement required by the fired member of Third Eye Blind. However, the insurance company denied the claim. And of course, Third Eye Blind came to their agency, Near North Entertainment Insurance Services, and said, whoa, why aren't we provided with coverage in this situation? We paid our premiums, and the reason was, and I'm sure it was set forth in a lengthy letter from the insurance company, but I don't know that Third Eye Blind did a whole lot of reading of the reasons. So the reason was that there was an exclusion in the commercial liability policy that had been obtained by Near North for the Third Eye Blind band, and that exclusion excluded coverage for any damages arising out of the field of the entertainment business. Well, just about everything that Third Eye Blind does is going to be related to the entertainment business. So it seemed like kind of a ridiculous exception or exclusion to have within their commercial general liability policy. And of course, there was the court case then by Third Eye Blind against their agency, Near North Entertainment Insurance Services, and the court didn't have too much trouble finding that Near North had a duty to advise the Third Eye Blind folks about their coverage and about what type of coverage they should have, and that there was an inadequacy in their commercial general liability policy that excluded damages arising out of the field of entertainment business. Certainly, Near North Entertainment Insurance Services was holding themselves out as the experts in this area. Their very name suggests they're working in the entertainment business and they're selling insurance. It's also obvious that the entertainment industry is what Third Eye Blind was involved in as a rock band. So a duty to advise was in fact implied here by the court upon Near North to allow Third Eye Blind to get whatever damages they have suffered as a result of Near North not obtaining the correct coverage that would have provided Third Eye Blind with the defense to the action filed by their fired member. So that leaves us still with the question, how do you determine when there's a duty to advise? A duty to advise is something different than the duty to procure insurance. And I'll talk a little bit more about the duty to procure later on in my discussion, but I want to focus on the duty to advise. That's really what this talk is all about. And the courts generally have said what this Indiana Supreme Court said earlier this year in the Indiana Restorative Dentistry case, and that is that the duty to advise only arises when there's been a special relationship between the policyholder and the agent. The general rule about there being no duty to advise is in fact the general rule just about everywhere, and certainly in Indiana and in California where the Third Eye Blind case came up. So that was an exception to the rule, and as it turns out, the Indiana Restorative Dentistry case is going to be another exception to this rule of the duty to advise being covered by a general rule of there being no such duty. So what is this special relationship that justifies applying a duty to advise on the part of an insurance agent? Now the focus of this, and this is what is said pretty uniformly, is that it's the nature of the relationship as a whole and not any one in particular factor to be looked at in order to determine whether or not you have an actual special relationship between the two parties that would justify this duty or obligation to advise. The nature of the relationship must be one of trust and intimacy, and although it may be hard to define, the Indiana Supreme Court has set forth the same factors that are frequently recited when looking to whether or not there is a special relationship. And the first thing that the Indiana Supreme Court pointed out was that all special relationships are long-term, but not all long-term relationships are special. In other words, in order for there to be this special relationship, it can't have been a one-off type of insurance arrangement where you, the policyholder, came in and got a policy from an agent, and then at some later point in time want to assess this duty to advise against the agent that sold you the single policy. It must be some sort of long-term relationship, and indeed, in the cases that have held there was a special relationship, the relationships between agent and policyholder has always been in excess of 10 years. And in fact, in the Indiana Restorative Dentistry case, that dentistry outfit was with the same agency, the Laven Insurance Agency, or its predecessor that merged into the Laven Insurance Agency, for over 30 years. So they fit that category. Now, what the court means by not all long-term relationships are special is just that you got to have more than just having been with the same agency for an extended period of time in order to show that there's some sort of special relationship between the policyholder and the agency such that a duty to advise is going to be implied in that relationship. Another thing that the Indiana Supreme Court did was they went through and set forth the 4 factors that they said are not exclusive by any stretch of the imagination, but these are the 4 factors that are typically looked at by courts in Indiana and elsewhere as well in determining whether or not you have a special relationship significant enough to imply this duty to advise. And let's just go through these 4 individually. The first one is whether or not the agent exercised broad discretion to service the policyholder's needs. What did the policyholder do when he came in or when he was acquiring the insurance from the agent? Did he leave the details all up to the agent? Did he tell the agent, well, whatever you recommend, I'll go with and I'll purchase. I don't know what kind of policy limits I need for my business, but you go ahead and pick them out, and we'll just go ahead with whatever you suggest. You know, and it's not entirely unusual for that type of attitude to be expressed by business owners, even business owners who have substantial business interests, simply because they're pressed for time. They don't have the expertise in the insurance industry. They just prefer not to deal with insurance. It's a necessary evil, the way they look at it. And so as a result, they don't always have the most hands-on approach to acquiring the types of insurance policies that they need or the amount of insurance coverage that they need. And so they have a tendency sometimes, and I'm sure agents will tell you this, that they will prefer to rely heavily upon their insurance agent to make decisions for them that really ought to be made by the policyholder. Now, to the extent that that broad discretion was given to the agent and the agent accepted that broad discretion and started doing things like picking out the types of policies and the amounts of policy coverage that the policyholder would get, you know, that's going to lead to more of a finding of a special relationship here. And in the Indiana restorative dentistry case, the court specifically said that although Laven was responsible for recommending coverage, the dentistry insurance, Indiana restorative dentistry, continued to decide their own policy limits. So it was kind of conflicting here. They weren't going to say that it lent itself one way or the other on that first factor. But moving to the second factor, and that is, did the agent counsel the policyholder concerning specialized insurance coverage? And specialized insurance coverage is something that was more of a focus in the way of finding a special relationship in the Indiana restorative dentistry case, because they said that Indiana restorative dentistry was looking to insure highly specialized prosthodontist equipment. And that was, in fact, the reason why they wound up suing the Laven Insurance Agency, is because, as it all turned out, they wound up with $500,000 that was not in prosthodontic equipment that was not covered by their policy. So the court is saying that this was a specialized type of coverage that was involved here, and that lends itself toward finding a special relationship. What the courts in Indiana have focused on in this regard is one case some while ago, United Farm Bureau Mutual versus Cook, which is also cited in the Indiana restorative dentistry case, where there was a very specific analysis of insurance needs done by the agency. Mr. Cook, in that case, was disassembling a barn and moving it to another state, and wanted insurance coverage specifically for that business endeavor. So that is the perfect example of the type of specialized insurance coverage where a special relationship can and obviously was implied to this agent for that type of activity. The third factor focused on by the Indiana Supreme Court was whether or not the agent held himself out as a highly skilled insurance expert and whether the policyholder relied on that expertise. In the Lavin case, the Lavin Insurance Agency held itself out to over 400 dental offices specifically as an authorized administrator for Indiana Dental Association insurance plans. So they're focusing their practice on dentist offices, saying we are the experts in this area. In a similar way to Near North, focusing on the entertainment business for Third Eye Blind. So again, these types of highly skilled insurance expertise, if you're going to hold yourself out as being the expert, that's going to lend itself to a finding of a special relationship, which may in fact lead to a finding that you had a duty to advise your customer, the policyholder. The fourth factor is whether or not the agent received compensation above the customary premium paid for the agent's expertise. I haven't seen this one be cited in any of the cases that I've read, and I would expect that if there was an actual payment over and above the premiums, that would probably in and of itself create a special relationship, contractual relationship, if nothing else. So what we have here are four different factors that are focused on by the Indiana Supreme Court, and I would say that there's a fifth factor when they trot out this idea that all special relationships are long-term, but not all long-term relationships are special. So they're also looking at the length of the relationship as being a part of the determination about the nature of the relationship and whether it arises to the level of a special relationship that can give rise to that duty to advise. Now, we've focused on a couple of exceptions to this general rule that there's no duty to advise, but I've done this for the purpose of showing you the different ways in which we can run into trouble from the agency's standpoint. It is, in fact, extremely rare to find cases like this. And in the Indiana restorative dentistry case, the Indiana Supreme Court said that they had researched 30 years of cases and only found one case in which a special relationship was found as a matter of law, and that was that Cook case that's mentioned in the Indiana restorative dentistry case. Now, I said I'd talk about the duty to procure, but that's usually not the issue in cases like this, because if all you're focusing on, and this was the case in the Indiana restorative dentistry case, is that you would come to your agent saying, hey, I need full coverage, get me full coverage, and you wind up with something that's either not covered or isn't covered to the extent that you expected it to be covered. Saying you want full coverage is just not enough to create that contractual relationship that would require the insurance agent to be responsible for not getting you the coverage that you think you need after you've experienced the loss and had the claim denied or not covered to the extent that you wanted it. So the special relationship analysis presupposes that there's been a denial of your insurance claim or inadequate coverage like in the Lavin insurance case. As an insurance customer, you need to take the time to review your coverages. And I know that's not the most exciting thing to do, and certainly if there are other things to do, it can be put to the bottom of the priority list. But it is crucial when you wind up with an insurance claim and you can possibly lose out on coverage that would have been there if you had taken the time to watch out for it. When do you need to review your coverages? Whenever you've got new business coming in, whenever you're taking on a new line of business or a new product, whenever there are changes in the old lines of business. These are times to take a look at your insurance coverage to make sure that you have the type of coverage that will protect you in the event that you have a claim, whether it's a loss or a liability situation. And at the very least, at renewal time, you need to take a look at your coverages. Communication with the agent is key. The best insurance agents are not mind readers. They don't spend their days watching what goes on in your office or your plant or your workshop, where have you. So unless you're paying extra for the agent to act in the capacity of a risk manager, you can't simply rubber stamp the annual renewal applications and expect your insurance company to adequately protect your business interests. You need to take an active role. And what does that mean? Well, it can mean designating one person to be responsible for your insurance issues and your insurance communications. I've recently spoken with an agent who told me that many of his policyholder clients don't have anyone designated within their organization for those communications and to deal with those issues on a regular basis. And that is a mistake. So when a claim is denied, it's unlikely that a court is going to hold that the agent had a duty to advise you that your coverage was inadequate for what you were doing. The agent is not responsible for bad decisions or bad choices about how much coverage or what kind of coverage you need to protect your business. As for agents, agents need to be careful about taking on too much responsibility for policy decisions or coverage decisions which should be made by the policyholders themselves. That's all I have.
Bob, I'm sorry to cut you off, Bob. I do hope that we can wrap up your section soon so that we have time for the others.
That's it, Ken. Thank you very much for your attention. I'll turn it back over to you.
Perfect. All right, we're in sync. I appreciate it, Bob. Those are great tips for everybody, and we will welcome questions on Bob's presentation really at any time. But now we're going to turn it over to John Fisher, who's going to be talking about your liability insurer agreed to defend. Don't relax yet. And as with Bob, of course, I have a little bit of information about John's bio. Unlike our chairs, Charlie and Andy, is headquartered in our Indianapolis office. Bob is in South Bend. One of the interesting things in John's background is that when he was in law school, he wrote a note entitled Computers as Agents, a Proposed Approach to Revised UCC Article 2. However, John's note was not the inspiration for the Matrix movies. John?
Thank you, Ken. Well, unlike Bob's presentation, which was based on a situation where the carrier denies coverage, the starting point for my presentation is a liability carrier that has agreed to defend or indemnify its insured. While that may in some ways seem like the end of the story rather than the beginning, and it certainly is preferable to getting a denial of coverage, keep in mind that this is really only the beginning of the insurer-insured relationship with respect to the particular claim. Even though the carrier has accepted coverage, at least under a reservation of rights, it still has an incentive to minimize its payout, often at the policyholder's expense, and the ongoing nature of the defense relationship provides it with many opportunities to do so. At the same time it seeks to minimize its monetary obligation, the insurer will attempt to maximize control over the course of the defense, including key strategic decisions such as whether to settle or try the underlying claim. Sometimes the carrier's views on these critical issues and many other lesser issues that arise in the course of the defense are contrary to the policyholder's wishes and interests, and the question of who prevails on these issues can have huge impacts on the outcome of the underlying suit. So far from being a time to let down one's guard or let the insurer simply run with the claim, a carrier's acceptance of coverage is a time to stay vigilant and maintain close oversight over the insurer's conduct of the defense to ensure that your interests are adequately protected and to maximize the benefits of your coverage. My presentation also is based on a blog post from a few months ago, and it identifies 10 common post-acceptance issues that we have encountered time and again, and identifies ways that we have addressed those issues when they have arisen. The first issue I want to address, which is also the first issue that chronologically would come up in the course of a matter, is who has the right to choose defense counsel. Ideally, the policyholder would want its own counsel to defend the suit, someone who's familiar with the policyholder's business, key personnel, business goals, etc. Unfortunately, liability policies usually, and I would say almost exclusively, give the carrier the right to choose counsel. And by the same token, the carrier will choose counsel that they are comfortable and familiar with and who they've worked with before, but who may have no relationship with the policyholder and sometimes, unfortunately, little expertise in the type of claim that's being defended. So what is the policyholder to do when it disagrees with the insurer's choice of counsel? Many states have a judicially created exception to the policy language giving the insurer the right to choose counsel, which converts the insurer's right to defend into an obligation to pay defense counsel of the policyholder's choice. Now, this rule is activated when there's an existence of a conflict. The theory behind providing the policyholder with a right to choose its own counsel and to, in effect, trump the policy language that gives the insurer the right to do so is that the insurer-chosen counsel, either at the direction of the insurer, consciously or unconsciously, may defend the suit outside of coverage, or if there's little chance that the carrier will have a duty to indemnify, defense counsel at the insurer's direction may provide a less than robust defense. The trigger for what converts the insurer's right to choose counsel to the policyholder's right to choose counsel varies from state to state. Some states provide that virtually any reservation of rights that the carrier issues creates a conflict that gives the policyholder the right to choose. Other jurisdictions take a more nuanced approach and say that reservations of rights that are dependent on the outcome of the underlying suit creates a conflict that gives the policyholder the right to choose. A classic circumstance that case law cites again and again is where there's a claim where count 1 is for negligent conduct, count 2 is for intentional conduct. The carrier has reserved its right to deny coverage based on intentional conduct, and there's a possibility that the case could be defended to where if the policyholder is held liable, the insurer obviously would have an interest in having the policyholder liable for the intentional conduct rather than the negligent. And then still other jurisdictions say that the trigger for the policyholder's right to choose counsel is when actual conflicts arise, and that's where a policyholder is able to point to particular actions taken by the insurer or the insurer-directed counsel that give rise to a potential or actual conflict of interest with the policyholder. There are other variables to address in this issue that come up time and again. One question that carriers raise is, what is independent counsel? In most jurisdictions, that means, as I've indicated, that the policyholder has the right to choose. Carriers sometimes will claim that independent counsel means counsel that they still have the ability to choose who's not on their panel counsel list. I've not come across a jurisdiction, fortunately, that has adopted that approach, but the carriers certainly assure me that they're out there. Another issue that comes up is the timing of the carrier's obligation to pay the policyholder's chosen defense counsel. Again, most jurisdictions say that the insurer has to pay the policyholder's counsel on the same basis that it would pay its own counsel when invoices are issued in real time. Some carriers, again, with or without a basis, may take the position that they owe more of an indemnity obligation to reimburse defense costs at the end of the case. Again, if there's case law out there for that position, I have yet to see it. But it doesn't stop the insurers from arguing that. The takeaway is to pay close attention both to the reservation of rights and monitor the insurer's and its chosen counsel's activity for suggestions of real or potential conflicts between their interests and yours, which may allow you to pick counsel at the insurer's expense. And at a bare minimum, even if the insurer retains the right to pick counsel, the policyholder always has the right to have its own chosen counsel, monitor the defense, and associate with the insurer's chosen counsel. The next issue I'd like to address is what constitutes reasonable and necessary defense costs. This is a big way for carriers to try to reduce their outlay. Carriers often may take the position that large chunks of legitimate defense expenses are not, quote, reasonable and necessary. This is important because whatever the carrier says is not reasonable and necessary may have to be made up by the policyholder, at least until that issue can be litigated and resolved with the insurer. The biggest circumstance that we see this issue arise in is insurer challenges to the billable rates of the policyholder's chosen counsel. Insurer-friendly states, I believe California takes this approach by statute, limits the carrier's responsibility to the rates that it would typically pay its own counsel for similar work in the same jurisdiction. So, for example, if the policyholder's chosen counsel bills $500 an hour, the insurer in a state such as California pays only $300 an hour for similar work in the same jurisdiction, the policyholder may have to, at least in the short term, make up the other $200 an hour, reducing the carrier's allegedly complete duty to defend to only paying 60%. Other more policyholder-friendly states follow a variety of more advantageous measures of what's reasonable and necessary. Some states follow a lodestar method, which is the method used in other fee-shifting contexts. Other jurisdictions, such as Indiana, use the market-tested approach, which means the rates that a policyholder is willing to pay its own defense counsel in uninsured matters where there's no hope of recovery from the insurer, on the theory that the policyholder has its own incentive to economize, so the insurer or a court dealing with that issue shouldn't be able to step in and second-guess the rates that the policyholder's counsel charges. Another approach that's used is Rule of Professional Conduct 1.5 approach. That is a multi-factor approach. Some of the factors are the difficulty or novelty of the issues, the amount involved, and the experience and reputation of the attorney. Other issues that arise where carriers challenge reasonableness and necessity are clerical work. We see this a lot. Carriers tend to pick on paralegals a lot, claiming that their work is clerical and unreimbursable. Excessive work, for example, over a preset maximum of hours that the carriers will agree to pay. Carriers will take issue if more than one attorney is in attendance, even at key case events like depositions, hearings, and mediation, where more than one attorney may be essential to the defense. And they challenge a variety of charges as overhead. The basic takeaway is, on both of these issues, is know your rights on the rate issue up front to avoid having to pick up a portion of the tab. And be prepared on an ongoing basis to challenge carriers line by line picking apart of bills. It may be relatively small amounts, invoice by invoice, but over time they certainly add up to a significant amount. Issue 3 is who has the right to control defense and settlement decisions and strategy. This issue is essentially governed by the same analysis as the choice of counsel analysis. Under the policy language, the insurer typically has these rights, but if a conflict is established under one of the tests, the policyholder then has the right to control defense and settlement decisions. If the insurer retains the right to control defense and settlement strategy, all is not lost. The policyholder still has some leverage in defense decisions. The insurer still must defend within the bounds of good faith and giving adequate consideration to the policyholder's interest. Examples that we've seen where these issues may come to a head are where an insurer seeks to move for a partial dismissal of only covered claims in a suit, leaving only the uncovered claims left, with the thought being that once the insurer has the covered claims out of the suit, it may seek to deny its defense obligations for the uncovered claims. Another issue where we see this come up is where the claimant has made a settlement demand within policy limits. If there is a risk of judgment exceeding limits that might have to be picked up by the policyholder, that's another issue where we have seen this type of dispute arise. In these situations, the policyholder, as I alluded to, certainly can use the threat of a claim of breach of contract or bad faith as leverage to object to the insurer's chosen course of action and to try to persuade them to back off of it. A more practical approach that we've tried at times, either in addition to the threat of bad faith approach, but less of a blunt instrument, is to have policyholders' counsel associate with insurer's chosen counsel, try to sway the insurer's chosen counsel to the point of view of the policyholder, and then if defense counsel chosen by both the policyholder and the insurer are advocating for the same course of action to the insurer would be hard-pressed to go against both counsel's advice. If the policyholder controls defense and settlement, obviously it makes things a lot easier. The carrier disregards the counsel's recommendations at its own risk, and if there are disputes over the course of defense or settlement, there's much more leverage for the policyholder here. Issue 4 is whether a policyholder is obligated to contribute to a settlement or judgment. This arises primarily, we've seen, in the context of cases where there are covered and uncovered claims. It can arise in other circumstances where the policyholder may be responsible for payment of a deductible or a self-insured retention. Hello?
John, I know I'm still here, so I think try to muddle through that.
Okay. Hello?
John, I think we're still good.
Okay. Well, picking up where I left off then, other contexts where the policyholder may be obligated to contribute to settlement or judgment costs are in the deductible or SIR context where judgment exceeds policy limits. I'm really going to focus this on the issue where there are covered and uncovered claims in the same lawsuit, and the insurer may turn to the policyholder for contribution for a portion of the settlement or judgment to account for those uncovered claims. If we're in a judgment context, the issue comes up, does the insurer or the policyholder have a duty to seek an allocation of the judgment between covered and uncovered claims in the underlying suit, for example, through the use of a special verdict form? In my experience, not many jurisdictions have addressed this issue, but those that have, that I've seen, suggest that whichever party has the right to control the defense may actually have an obligation affirmatively to seek an allocation between covered and uncovered damages in the underlying suit. Just something to keep in mind. These disputes between what the policyholder may owe to contribute to a settlement or judgment and how much sometimes can be resolved simultaneously with the resolution of the underlying matter. If they cannot be, then one option is for the parties to reserve rights to go ahead and settle or resolve the underlying matter and then litigate coverage afterward. Issue 5, classifying costs as defense or indemnity. This typically really arises only in the context of environmental cleanup demands received from government agencies, where the policyholder often is obligated to hire an environmental consultant in addition to defense counsel to investigate the source and scope of the contamination, to propose a remedial plan of action to the government agency, and to execute the remedial plan ordered by the government agency. The question in this circumstance is whether those consultant fees, which often can be far greater than the defense counsel's fees in this context, do those costs count as defense or indemnity costs? This is important for two big reasons. One is that defense costs don't count toward the limit, typically. The insurer owes those costs in addition to the limits, whereas indemnity costs do count toward the limits. So the carrier has an incentive to classify as much of the consultant fees as possible as indemnity costs to limit its total outlay. Another big reason why this is critical is that if a carrier is defending under a reservation of rights, the carrier may actually deny indemnity obligations outright, which, if they're claiming that consultant fees constitute indemnity costs, could result in denial of the vast majority of costs incurred with respect to these types of claims. Now, the outcome of this issue differs by state. I say some states treat all consultant costs as indemnity. Again, as with a couple of the other issues, I've certainly had carriers take that position. I have never had the misfortune of litigating this issue in one of those states, but again, the insurers insist that they exist. Other states take a more reasonable approach and treat at least some consultant costs as defense costs that are paid in addition to the limit of liability. There are no bright lines, but some of the rules of thumb that are often applied are that costs to investigate contamination count as defense costs outside the limits. Costs of actual remediation counts as indemnity costs that erode the limits. Another test that courts look at is what is the primary purpose of the cost, and if the primary purpose is to limit liability, then it's counted as a defense cost. For example, pilot testing to determine the most cost-effective remediation option. Sometimes carriers claim that that is an indemnity cost because technically there is some extraction of contaminants from the soil or groundwater, but that's not the primary purpose of the pilot test, which is to determine what's the most cost-effective option to limit the policyholder's ultimate liability for remediation costs. The next issue is whether the insurer owes pre-suit or pre-notice costs. The pre-suit cost scenario arises where the policyholder receives a demand or a lawsuit threat before a lawsuit is filed, but that still requires the policyholder to react with typical defense-type activity, investigation of the claim, interviews, legal research, exploration of settlement opportunities, and so forth. Costs that would be covered as defense costs if they happened after the filing of a suit. The pre-notice scenario arises typically where a suit is filed. It implicates policies that are sometimes decades old, very difficult to find, so sometimes takes the policyholder a year, 2 years, or more to find the policies, and by the time they provide notice to those carriers, you're 3 years down the road in a lawsuit. In both of these instances, obviously significant defense costs may be incurred, and I say before the duty to defend is triggered. I think it's actually more accurate to say costs that are incurred before the claim is tendered to the insurer. Some states have a bright line rule that no pre-suit or pre-notice costs are covered. Indiana, unfortunately, is one of those jurisdictions for pre-notice costs. Other jurisdictions allow partial or full recovery of those costs under certain circumstances. In the pre-suit context, if the demand ripens into a suit eventually, necessary pre-suit defense costs may be covered. In my experience, not many states have affirmative law on this, but obviously we always take this position in every jurisdiction. For pre-notice costs, many states require the insurers to pay those costs absent a showing of prejudice. There's variability among jurisdictions on how high the burden on the insurer to show prejudice is. Some states have a low burden. Other states have a high, nearly insurmountable burden. So the takeaway is that even if the insurer's position that it's not responsible for pre-suit or pre-notice costs may have some intuitive appeal at some level, you always should check your jurisdiction's laws to see whether those costs are covered. Don't take the carrier's word for it simply that those costs are excluded from coverage. It looks like I'm running short on time, so I'll try to blow through these last four. The next one, sharing information with the insurer. Really the key here is that sometimes the carrier or the carrier's defense counsel seeks information that is relevant to the defense, but that also may be harmful to the policyholder's coverage position. In these circumstances, there's a tension between the policyholder's obligation to cooperate in the defense and its self-interest in maximizing coverage. This can be a very sensitive issue and fraught with peril. It's essential to be very careful and thoughtful in how you respond, including how you respond, to whom at the insurer you respond, and under what circumstances information will be provided. In the words of Walter White, for any Breaking Bad fans out there, tread lightly. Next issue, National Coordinating Council. I will only remark to say that National Coordinating Council costs should be included as reasonable and necessary costs. We always take that position. We have had those types of disputes with carriers before, and the case law in general is in favor of the policyholder on getting National Coordinating Council costs paid in the appropriate case. With respect to deductibles and self-insured retentions, the key here really is that there are many variations in the language of deductible endorsements and self-insured retention endorsements. There are many different ways that they address whether the policyholder has an obligation to pay any defense costs, whether the obligation to pay defense costs is entirely shifted to the policyholder, whether the policyholder's payment of defense costs erodes the deductible or SIR such that the insurer has a delayed obligation to pay defense costs but eventually may need to step in and pay. And in multi-policy situations, whether the policyholder must satisfy one SIR or many SIRs. Regardless of whether the particular endorsement is styled as a deductible or an SIR, it's key to look at the substance, not the form. The specific language, and sometimes unique language, of the particular deductible or SIR at issue controls on the policyholder's obligations under a deductible or SIR, not the label that's placed on it. Finally, in multiple carrier situations, many of the issues I've covered today become exponentially more complex when multiple carriers' policies are triggered. Just to highlight a couple, one comes up, I've had it come up fairly frequently. What happens when some carriers defend under a reservation, thereby giving the policyholder the right to choose counsel and control the defense, and other carriers defend without reservation, meaning that they retain the right to choose counsel and control the defense. Sometimes we've had some success in getting the carriers that retain the right to choose counsel to stand down on the basis of the other carrier's conflicts. Sometimes we're just stuck with a situation where we have to manage more than one defense counsel being involved with clashes over control of defense activities, etc. Another big issue that comes up in multi-carrier situations is how defense costs are allocated among carriers and whether the policyholder has an obligation to participate. Some, and I would say most jurisdictions, say that the carriers have an obligation among themselves to provide a complete defense without any policyholder participation, while others may require the policyholder to pay a share of defense costs for years with high SIRs, no insurance, or inadequate evidence of insurance. We obviously always take the position that that is not the case, but in some jurisdictions our ability to make that argument is limited. In some jurisdictions, however, there is the ability for a policyholder to elect a single carrier to provide a complete defense. And that right obviously comes in handy either as a right to actually exercise and choose a single carrier, or sometimes we use it simply as leverage, as a threat to get carriers to agree among themselves to provide the coverage. So in conclusion, active, diligent monitoring and management of the insurance claim is critical, even after the carrier, quote, accepts coverage. And awareness of the numerous ways in which carriers may try to limit their obligations and preparedness in asserting your rights could make a difference in the 6 or 7 figures or more. And coverage counsel knowledgeable about the nuances of state law on these and other issues can assist in maximizing policy benefits and minimizing policyholder contribution. Thank you.
That's great, John, and I appreciate your trying to cover a lot of material in a very short period of time. I know that many of those subjects are worthy of full-blown half-hour or hour presentations in and of themselves. But moving along, our final speaker for today will be Chris Lynch, whose topic is If One is Exhausted, Will Another Follow? And he'll explain what that means in just a moment. But Chris is a partner in our Minneapolis office, and one of his previous subjects of speaking and presenting in other sessions has been insurance coverage for life sciences. However, Chris assures me that he is not entering a genetically modified beeswax carving into competition at the upcoming Minnesota State Fair. Chris, take us home.
All right. Well, thank you, Ken. Well, today Bob has talked about some of the issues that arise when your insurer denies coverage, and John has discussed some issues that arise when one of your insurers actually accepts some of its coverage obligations. So continuing with that progression, what I'm going to be discussing is what happens when your insurer, who's initially been handling or defending the claim, has paid out or exhausted its limits of insurance, and you need to go on to the next carrier in your coverage tower. And specifically, we're going to be discussing some of the things that you should be keeping in mind at the front end in structuring your insurance coverage tower, and then as you're wrapping things up with your primary carrier and presenting the claims to your excess carrier in order to try and maximize coverage and avoid potential coverage disputes as you move up the coverage tower. Now, whenever I talk about this topic, I like to begin with some visual aids to try and help reinforce the message. And so here we have pictures of the Tower of London and the Eiffel Tower. Now, when you're structuring your insurance coverage towers, this is the goal you should have in mind. This is the ideal. You want strong, dependable coverage that you can rely on, and you know that's going to be around, and you know is going to be there when you need it. In reality, this is probably what most insurance coverage towers actually look like. You've still got a coverage tower, but it's got some flaws that may not create a coverage dispute, but certainly there's the potential there for a coverage dispute down the road if a claim comes in. And ultimately, what you want to avoid is a coverage tower that's structured so it's just waiting to collapse when a claim comes in, and that would leave the policyholder to clean up the mess that results when a coverage tower collapses. There's no standard form excess insurance policy. It's not the same as the primary CGL policy that we're all used to. Each carrier has its own type of excess forms, and as we'll see going through this presentation today, even minor differences in the language of the excess coverage forms can really have significant differences on the type of coverage provided. But in a nutshell, excess insurance is there to cover amounts of loss and liability that exceed the underlying limits of insurance that are provided by your first layer policy. Today, what we're going to be focusing on is the final bullet point on this excess coverage feature, that excess policies only attach when the underlying limits are exhausted. And this is an area and an issue that's becoming the focus of a lot of litigation, particularly in recent years. A lot of excess insurers are getting more and more bold about challenging exhaustion of the underlying limits and whether that exhaustion actually met the obligations both of the excess policy and of the underlying policy. And I think the rationale is that rather than ever having to debate whether the substance of the underlying claims is actually covered by the excess policy, they put the onus on the the policyholder, saying that you never get to address coverage under the excess policy because the policyholder has not satisfied its initial burden of having to show that the underlying limits were exhausted. Really, these exhaustion issues tend to fall within one of three buckets. The first is functional versus actual exhaustion. This is kind of the public policy argument. Does an excess insurer really have any basis for challenging whether or how the underlying limits are paid out, particularly if the policyholder is only going after the excess insurer for those amounts that are in fact in excess of the total underlying limits. Another area of challenge in litigation has been limits in the excess insurance policy. Probably in response to some of the public policy arguments, excess carriers have increasingly been inserting provisions in their policy that put express limits or requirements on how the underlying limits have to be paid out. And there's been a rash of court decisions interpreting how those limits should apply. And the third area where exhaustion comes up in litigation is the requirement or necessity of proving proper exhaustion. And this is an area where excess carriers aren't challenging whether the underlying insurer has in fact paid out its limits, but they're challenging whether the underlying carrier paid out those limits in accordance with the coverage terms of the underlying policy. Basically, I would argue going in and second-guessing the coverage determinations that have been made by the underlying carrier. On the functional versus actual exhaustion issue, again, this is really the public policy argument, and this argument is to some extent bookended by two landmark Second Circuit decisions, as we say, from Z to A. The first is Zieg versus Massachusetts Bonding Insurance Company. And that was a case involving a first-party excess insurance policy where the court allowed the insured who had settled with its underlying carriers for payment of less than their full limits to nevertheless try and seek excess coverage from its excess carrier for those amounts that were in excess of those underlying limits. Now, the excess carrier argued that because the insured had failed to collect the full amount of the underlying limits, it hadn't exhausted those limits in accordance with the requirements of the excess policy, which required the limits to be exhausted through payment of claims. The Second Circuit said, well, payment of claims is ambiguous. It doesn't necessarily just equate to payment in cash. You can have functional payment or the equivalent of payment through settlement with the underlying insurer. And in supporting that decision, the court, as the quote here shows, noted that an excess carrier really has no legitimate rational interest in whether or how the underlying limits are paid out, so long as it's only being asked to pay those amounts that are within its coverage layer. Following Zieg, a number of courts accepted and adopted similar public policy statements, basically rationalizing that because public policy encourages the resolution of disputes through settlement, they want to encourage settlements between insureds and their underlying carriers. And unless the policy language in the excess policy specifically prohibits it, they were going to allow exhaustion through those settlements because, in part, excess insurers, they thought, had no legitimate interest in challenging whether or how underlying limits are paid out if they're only ever going to have to pay those amounts that are, in fact, above the underlying limits. That changed to some extent in 2013 when the Second Circuit issued its opinion in Ali versus Federal Insurance Company. That case involved an excess liability policy, and the court seemed to suggest that in the liability context, excess insurers do in fact have a legitimate interest in making sure the underlying limits are in fact paid out. And the court suggested that their interest is that they want to make sure that the underlying insurer or policyholder are actually defending against and trying to limit the total amount of their obligations to the underlying claimant. They're not just going to blow through those underlying limits to try and reach the excess layer, because that would be the equivalent of asking the excess carrier to drop down before it's bargained for time. Now, in view of the ongoing public policy debate as to whether can functional exhaustion suffice, or does the excess carrier have a legitimate interest in requiring actual payment of the underlying limits by the underlying insurer, to head off those public policy debates, a lot of excess carriers have begun inserting express limits in their policies on how the underlying limits can be exhausted. And these take the form of, to address the holding in Zieg, what is payment of limits? They also put in restrictions on who needs to pay. And some policies go so far as to put limits on what payments or what types of claims count towards exhaustion. Perhaps the best way to see some of these differences is to look at some actual policy language from excess policies that have been addressed in the courts. If you look at these three examples of actual policy language, you'll note that they have different provisions as to who needs to pay the underlying limits. The first example, there is no requirement as to that the underlying carrier has to pay the underlying limits. And the court, deciding and addressing this policy language, recognized that and said that under this type of language, the insured could settle with the underlying carrier so long as the insured would pay the difference between the settlement and the underlying limits, and then it would be free to go after the excess layer. Contrast that to the second example here, which specifically says that the underlying policies have to be paid by the insurers. The court said that, addressing this language, said that under that language, because the underlying insurer had not paid its policy limits, the insured could not settle with the underlying carrier and fill in the gap. It had to be the underlying insurer to pay those limits. And if you look at the third example here, this is a good example of just how far excess carriers are going in inserting restrictive language into their policies on exhaustion. There, it not only requires that the underlying carriers pay their policy limits to exhaust, but it also requires them to admit liability for those payments. And any of you who have been in a dispute with your insurance company, you'll know it's hard enough to get the insurance company to pay out the money that it owes. It can be nearly impossible to get that insurance company to actually admit that it was responsible to pay those amounts. So, again, we represent only policyholders, so I'm somewhat biased in this statement, but I cannot think of a good reason why any policyholder would ever want to agree to the type of language that's in that third example there. But again, it's a good example of just how far excess carriers are going to insert restrictive language into their excess policies. And in fact, there, the court addressing that language held that it did require the exhaustion by having the underlying insurer both pay its underlying limits and admit liability for those limits. One takeaway from this is that the language isn't always so clear how courts are going to interpret the language. If you look at these two quotations from different cases that have addressed an exhaustion issue, the language in both appears to be pretty much the same as to what the restrictions are on who has to pay what to exhaust the underlying limits. The outcomes, however, were dramatically different. In the first quotation, the court held that that clearly meant that the policy limits could only be exhausted by actual payment by the underlying insurer. And therefore, the insured was unable to access its excess policy. In the second example, which, as I read it, I would say is language on its face at least looks pretty much the same, the court held that, well, this is ambiguous. And therefore, this doesn't mean that the underlying carrier has to pay the full amount. And in fact, the insured can settle with the underlying carrier, make up the difference, and then still go after its excess carrier. In addition to putting in restrictions on who has to pay the underlying limits, excess insurers have also been putting in limits on what claims count. And this is most often done by putting in a provision that says any losses that are paid by the underlying carrier that aren't on claims that would also be covered by the excess carrier don't count towards exhaustion. Now, when you have a gap or a difference in the coverage between your primary and excess carriers, this can functionally mean that you can never exhaust your underlying limits because the underlying carrier will pay those claims that are within its coverage. But if its coverage differs, then the excess carrier and any payment of those underlying limits was paid on a claim that's not covered by the excess carrier, the underlying limits can never exhaust unless you've got a provision in the policy that allows the policyholder to make up that gap. Again, the language is not always clear as to how a court's going to interpret it. a recent decision out of the Fifth Circuit, the insurance company argued that the highlighted language in this quotation effectively meant that because certain of the claims paid by the underlying carrier were not covered by the excess carrier, that the underlying limits hadn't exhausted. The court said, no, you can't read this in isolation. They looked at the totality of the language in the underlying policy and the excess policy and held that the payment of the underlying limits, in fact, did not require and was not limited to only those claims that were covered by the excess carrier. So again, the lesson is that the language isn't always clear as to how it's going to be interpreted, and even if you are confronted with a claim where you think the language is against you, you might have arguments for coverage. The final issue in exhaustion, the challenges to exhaustion, is the necessity for proper exhaustion. And this really means, can the excess insurer challenge whether amounts paid by the primary insurer were properly paid out, were paid out in accordance with the terms of the primary policy? Essentially, this is allowing the excess carriers to second guess the coverage decisions made by the underlying carrier. There's 3 Minnesota cases that really highlight how courts are looking at this issue. The first is Royal Indemnity Company versus C.H. Robinson Worldwide. There, the court allowed the excess carrier to challenge whether defense expenses that have been paid by the underlying carrier were in fact reasonable. And the court's rationale was that the excess policy limited exhaustion to payment of loss. The primary policy defined loss to include only reasonable defense costs, and therefore the court held that under the terms of the excess policy, the underlying limits could only exhaust through payments of reasonable defense costs, and therefore it let the excess carrier go back and challenge whether the defense costs that had in fact been paid by the underlying carrier were reasonable. And you can imagine from a policyholder perspective, the difficulty that poses in that you could have a carrier pay claims and have to fight the same battle over the same payments every step up the coverage ladder. In American Insurance Company versus St. Jude Medical, decided not that long after C.H. Robinson, a federal court in Minnesota distinguished the case before it from C.H. Robinson. There it noted that there was no express requirement in the excess policy that underlying limits could only exhaust their payment of loss, and therefore really all the insured had to show was that the total amount of underlying limits had been paid out, and the excess carrier did not get to go back and challenge whether those underlying payments were in fact covered by the underlying policy. But then only a couple years later, another federal court sitting in Minnesota seemed to conflate the two issues. There, the court allowed the excess carrier to go back and challenge payments, and this time it was the application of a deductible by the underlying carrier. And in doing so, the excess carrier purported to have a textual hook for allowing the excess carrier to go down. But really, if you look at the 3 provisions that it cites, those are just general provisions referencing and incorporating by reference some of the provisions of the underlying policy, and really weren't a specific statement that the underlying policy could only exhaust through proper payments. So that the challenge to proper exhaustion is an area where insurance companies are becoming increasingly bold, but I think it's an area that's going to continue to develop, and we're going to continue to see challenges by excess carriers. So the takeaways from all this. The first is, in placing your excess coverage and structuring your towers, don't assume. Your excess policies will be labeled follow form policies. Don't take any comfort in that fact. They are not follow form policies. Probably they've got their own conditions, own differences, own restrictions. So you can't stop at the deck page when evaluating excess policies. You've got to really read the coverage forms and make an intelligent, informed decision as to what the coverage provisions are. Your goal is to seek uniformity in each layer. And again, because excess policies, there is not standard language, ask for different language or seek out a different carrier if the policy language you've been presented with isn't to your liking. When a claim does come in, try and get your excess carriers involved early in the process. Most excess policies, or many excess policies, allow the excess carrier to associate in the defense. Invite them to do so.
even if you can't resolve all the coverage issues, you'll at least know maybe what some of the coverage issues and concerns of the excess carriers are. So as payments are being made in each layer, you can make sure that you're prepared to, to confront challenges that are made by the excess carriers once the coverage reaches their layer. And in this respect, you'll have to be persistent. A lot of excess carriers do not want to become involved earlier than they need to be, and will be content viewing the case at 30,000 feet without giving you any substantive input. So you really want to be persistent in trying to get some feedback from your excess carriers. And finally, when you do come to the end of a layer of insurance and you need to either settle with your underlying carrier, or your underlying carrier might be asking for a release of limits, that's when you really need to review all of the policies and make sure that the settlement or release of the underlying carrier isn't going to be a potential violation of any of the terms of the excess policy. I mean, look for those provisions. Can the insured fill in the gap if there's a settlement? Even if the underlying carrier is paying out its limits, you want to be careful to make sure that the payment is being allocated to payment of the underlying claims and not to payment of a release from some of the coverage claims that the insurer might have raised. In that respect, you really want to review all of the policies in the chain before you ever settle with the underlying carriers. And that's all I have.
Terrific, Chris. And I know we're running short of time, so I'm going to do a quick wrap-up here. First of all, I want to thank all of our speakers for doing a terrific job, and especially for soldiering on through some technical difficulties. And I want to apologize to our audience for those technical difficulties. It's really not the way we like things to go, but I can only assume that we've just been hacked by a rival law firm. All of you will soon receive an email with a link to receive all of these slides that will also allow you very easily to contact any of today's speakers, also to track our practice group and our practice group's blog. You will also get information then for how to get your CLE credit. And at any time, we welcome any feedback and suggestions or questions from our audience. And as a final point, I'd like to ask everyone to save the date of October 29th. That will be our next program, and it's going to be a little different this time. It will be a live program hosted here in our Chicago office, and it will be webcast out to all of the other Barnes & Thornburg offices. It will also be a partnership between our practice group and another within the firm, as well as an outside organization that we're very excited about. And details on all of that will come to all of you very shortly. So once again, thank you all for listening and lending your ears to us. And we look forward to hopefully seeing all of you in October. And thanks again. Have a good day.